Panel one, come on up. Coordinate with them. I'll have them go. Yes. You guys have something? Really hard. I know this is not. All right. Well, for our first panel of the day, I'm delighted to introduce three close and longtime friends of mine. This panel is going to focus primarily on election law and the relationship between state and federal government, including the courts, in running elections. And I think you'll find that the presentations will all be especially timely to issues that are very much in the news right now. I'm going to start while they're seated, coincidentally or not, in the order that they're going to present. So I will introduce them in order and then invite them to come up. I think this is the way most of our panels are going to be structured today. I've asked them to try to keep it to around 10 minutes, maximum of 15 for presentations. I'll then follow up with a question or two. But you all, as you're listening, please be thinking of questions or comments that you might have for the panelists. I'll ask you to try to keep those reasonably brief when the time comes, but we really do want to have the opportunity for robust participation. So starting from my left, Josh Douglas is an election law and voting rights expert. He teaches at the University of Kentucky J. David Rosenberg College of Law. He's the author of one terrific book and many, many law review articles, focusing on a variety of areas. One of the greatest contributions I think Josh has made over the course of his career, his long and distinguished career now, is to understanding the importance of state law, especially state constitutional and state constitutional rights to vote, to the functioning of our democracy. His article, Procedural Fairness in Election Contests, was the winner of the Steele's Calls for Papers many years ago, another great paper. He's the co-author of an election law casebook with, among others, my longtime friend, Ned Foley from Ohio State. And Josh, we're really thrilled to have you here. Ellen Katz, my very, very dear friend, the Ralph W. Agler Professor of Law and Associate Dean. Oh, we have two Associate Deans on this panel because Josh is also an Associate Dean. My condolences. She's the Associate Dean for Academic Programming at University of Michigan Law School, as well as the Agler Professor. She is an expert on election law, civil rights and remedies, and equal protection. Her scholarship focused largely on racial equality when it comes to representation, including the Voting Rights Act. Ellen has, with the help of various students over the years, created this great database of Voting Rights Act cases, including questions under Section 2 of the Voting Rights Act. She'll be talking about a different section, Section 11B of the Voting Rights Act today, and its private enforceability against private parties. And then on the far side of the table, Professor Nicholas, or Nick, Stephanopoulos, we're all friends here, so we'll say Nick, a professor who teaches at Harvard Law School. He teaches election law, constitutional law, administrative law, legislation, comparative law, focusing on democratic theory. He's one of the few people in the election law world who, in addition to being a brilliant scholar when it comes to theory and doctrine, is incredibly skilled at empirical methods, which has allowed him to do things that nobody else can. There are so many articles of Nick's that I'm a big fan of. One of them several years ago that I cite and think about all the time, political powerlessness, trying to measure how much political power different groups have in our system. He's also involved in many cases, including right here in Wisconsin a few years ago, the Whitford versus Gill, which ultimately became Gill versus Whitford in the U.S. Supreme Court, the lead plaintiff on that case, an emeritus member of our faculty, Bill Whitford. And he works on litigation and advocacy as director of strategy at Harvard Law School's election law clinic. Ned, Nick, and I just joined a great brief which Nick wrote in the Ohio Supreme Court. Too bad they did not see the light, sadly. But we can talk about that later. Please join me in welcoming all of our three distinguished panelists. Yeah, if that works for you. And over to you, Josh.
Wow, I think I need Dan just to come along with me to introduce me to friends. I'm going to dinner. Dan just introduces. Thank you for that warm welcome and that amazing introduction. And thanks to, as I said, to Dan, to Julie and Michaela, to Rob and Miriam, Bree, and everyone else here at the University of Wisconsin and the State Constitutional Democracy Project. I think I got that. State SDRI. There we go. Okay. Close enough. So, as Dan mentioned, I've written a lot about state law, state constitution, and the U.S. Supreme Court and the way in which the court has considered the right to vote. Talking about the constitutional right to vote, both how the U.S. Supreme Court has considered it, as well as state courts under state constitutions, has been a big focus of my work. And today I'm going to talk about a new article that is going to be published in the Symposium issue, which I can't wait to see in print, because the articles just up and down are incredible that the journal was able to solicit for this symposium. And so I want to talk a little bit about the basis for my article and kind of why I'm thinking about these issues. And it has to do specifically with new restrictions on voter registration. But let me back up just to give, since I'm leading off here, to give a little bit of an overview of the U.S. Supreme Court's approach to the right to vote and basically why it's been so bad. As Dan mentioned, I wrote a new book that came out this year called The Court versus the Voters: The Troubling Story of How the Supreme Court has Undermined Voting Rights. And the basic gist of the book is that although the U.S. Supreme Court in the 1960s once considered the right to vote as a fundamental right and applied heightened scrutiny and very carefully considered a state's justifications for its voting laws, the court no longer does so. And it's not just a recent phenomenon of the past 10 years or the Roberts Court. It actually started with cases in the 1970s, 1980s, and 1990s that laid the foundation for today's underprotection of the right to vote. The election law people in the room know a lot of these cases, like Anderson versus Celebrezzi out of Ohio, Burdick versus Takushi out of Hawaii. And I tell the behind-the-scenes stories of these cases. For example, I got to interview Alan Burdick, who is the person behind the Burdick case involving write-in voting, which was pretty interesting. But the underlying message is that the U.S. Supreme Court has been pretty terrible on voting rights. And there's really two themes that emanate from the way the court has approached it. One is what I've referred to as undue deference to state legislatures. Undue deference meaning we're just going to trust the state politicians to pass laws, which has a lot of effects in the Supreme Court's jurisprudence. It says things like, we're not going to police partisan gerrymandering. We're going to trust the state legislatures. It says things like, when we construe Section 2 of the Voting Rights Act, which prohibits discriminatory effects in voting laws, we're going to say that Well, if a law existed back when Congress amended the act in 1982, then it's perfectly valid today, even if the evidence shows that it has effects for today's voting rules. It's going to say things like on the constitutional right to vote and challenges under this what's now known as the Anderson-Burdick standard after those two cases I mentioned, that basically the thumb is on the scale of states. Voters have to provide a ton of evidence to show that a law is infringing on the right to vote, but states don't have to provide much evidence at all for what they're trying to achieve. So a state says, well, we want better election integrity. And the Supreme Court says, of course you do, and we're going to trust you. And we're not going to scrutinize whether a particular rule actually achieves that. So the one theme is this undue deference to states. The second theme we see not only in voting rights, but in lots of other areas, particularly of constitutional adjudication, is a push for history and tradition to drive the decisions, right? So the court, in a whole suite of areas, if you talk about abortion rights in the overturning of Roe v. Wade in the Dobbs case, talk about gun rights in the DC versus Heller, but then more poignantly in the New York versus Bruin case that really narrows the scope of what types of gun regulations that states can pass. And the message is history and tradition wins out. In fact, almost a myopic focus where the court is only looking at history and tradition. So you have these two themes coming out of the US Supreme Court: undue deference to states and history and tradition. And I wrote a lot in my book about the undue deference theme. I've written some other articles, in fact, an article called Undue Deference to State Legislatures in the 2020 Election Litigation. So this article for this symposium, I wanted to focus on history and tradition. And here was sort of the question I had. If the court is so strong and so pushing towards history and tradition driving the analysis, what if history and tradition is more pro-voter on a particular issue? Will the court still stay consistent and say history and tradition wins out, and so therefore we have to strike down these voter restrictions? Or are we going to go more towards the undue deference standard and say just we're going to trust the states? And so I looked at voter registration because there's a whole bunch of new restrictions on voter registration that states are passing just in the past few years. So you have things like compensation restrictions, rules that say organizations cannot provide compensation to their either volunteers or employees who are helping on voter registration drives. So the League of Women Voters, who does a ton of voter registration activities, get out the vote activities, it cannot pay their volunteers or their staff. So does that mean that they can't give them lunch if they're spending all day on a voter registration drive? Can they not provide reimbursement for the gas that their volunteers might be spending as they drive around to various voter registration drives? And it's not entirely clear, but the rules that are passed seem pretty restrictive. There are rules about who can engage in third-party voter registration activities. States say that only registered voters in the state. Missouri passed a new law that says voters who are those who help in voter registration drives must be registered voters of the state. Can't have non-citizens helping out. Can't have people convicted of a felony helping out. There's delivery deadlines. All voter registration forms must be turned back in to the state within, and I think the most restrictive one is 3 days after they're completed. Well, that can be logistically difficult for organizations that are gathering a whole bunch of voter registration forms, and they also have to think about, okay, making sure they go through the forms, making sure they're complete before they bring them in. It can really harm the ability of these organizations to do their work. Penalties for turning in incomplete voter registration forms. So and Florida is one of the worst offenders in terms of passing a lot of these laws that say things like if you turn in X number of incomplete ballots, one little thing missing, you can be liable for massive fines. In Florida, each violation is a $50,000 fine with a cap of $250,000. Well, that's going to bankrupt a lot of third-party voter registration organizations. So there's all these restrictions happening, and so there's been challenges to many of them. And my question was, is this consistent with history and tradition? And so I did a deep dive into the history of voter registration activities, and I found something pretty interesting, which is that at the time that states began requiring registration lists, which is really basically the late 1800s and early 1900s, at that very time, there was also robust third-party registration activities. That is to say, organizations were helping people register voters from the inception of voter registration. And I trace the history not only in the late 1800s and early 1900s, a lot of that has to do with the women's suffrage movement. And it was kind of fascinating. I did like deep dive into historical newspaper archives and found all of these newspaper articles talking about voter registration drives that were occurring. But also as you go through the 1940s and 50s, through the civil rights era, there was all this activity of third-party voter registration happening. Go through into the 1990s and the Motor Voter Law, the National Voter Registration Act. And the whole point was to help make it easier for third-party organizations to engage in voter registration activities. So if we think that history and tradition should be driving the analysis, then my argument is that these new restrictions are invalid because they are contrary to the long-standing history and tradition of voter registration activities. So these are going to go to the U.S. Supreme Court, probably, I would suspect. I mean, some of them are percolating through the lower court. And some of these restrictions have been struck down as violating the First Amendment right to association, saying that these sorts of restrictions are going to harm the ability of third-party organizations to exist, to continue their activities. But some of them have been upheld. And again, you have the situation where in Florida, it's a $50,000 fine for every violation. And so you have organizations that are just ceasing their work. There's some evidence from the League of Women Voters that said, basically, we're not doing this because of the fear that it would bankrupt us. You have groups on college campuses that have said there's much less activity on voter registration in college campuses with respect to attempting to get people to register for fear that it would violate these laws. So even when they get struck down, there's two harms here. One, the deterrence that has occurred already during the pendency of the lawsuit, and the resources it takes to fight these lawsuits, which maybe is part of the point, right, of trying to actually make it harder for these organizations to do their work. But again, if you compare it to the history and tradition of voter registration activities, and there's all these situations like, actually, I think it was one of the pieces of evidence was at the Wisconsin State Fair, where the precursor to the League of Women Voters set up a booth. It's a little bit patronizing in terms of saying we're going to teach women how to register and how to vote, but that was part and parcel of the activity toward women's suffrage. And there was no suggestion anywhere that these activities were contrary to the law. So voter registration existed in part, in the beginning of it, in part was to root out fraud in the election system. But no one at the time thought, not only were we going to have these registration lists, but we're going to prevent organizations from helping valid voters register to vote. So ultimately, the question is history and tradition actually going to win out, even if it leads to a pro-voter ruling? We'll find out.
So hello, it is a real treat to be here and see so many old friends, new friends, but old friends too. I won't date it. Among the dear friends here today is the wonderful dean of this magnificent law school. We will discuss later how many years we have been friends, but it is a real joy to be here, and thanks to the Wisconsin Law Review for all the terrific work you've put in to put this together. It's really a wonderful event. My paper, what to say about it? It's a long lead up to a really old question, a question that's at least 25 years old, maybe since 1965, or maybe it dates back 150 years now to the civil rights cases. And namely, can Congress reach private action when it's enforcing the 14th and 15th Amendments? Or more specifically, when Congress reached or prohibited voter harassment and intimidation, privately initiated voter harassment and intimidation, was it enforcing the 14th and 15th amendments? And to answer that question, we actually have to ask a question that, like, I will ask my students at times. So is voter harassment different than gender motivated violence? And it's the kind of question where you're like, you only have to be in law school to get a question like that, because you're like, wait a minute. Insofar as Congress's enforcement power extends, and that's the way we're thinking about it. The paper has a long windup. In part, and it might be unnecessary, just get to the question, and I might throw out the first pages of it. But in part, the windup is, why are we talking about it? Why has this become an issue now? And in part, 11B of the Voting Rights Act, which the paper is organized around, part of the original Voting Rights Act, had this question baked in from the beginning. So why is the question of congressional power, why didn't we figure this one out a while ago? And in part, the Voting Rights Act itself insulated this provision because the question whether it enforces those amendments, which I will say it does, isn't necessary for the constitutionality of the provision, because of the provision that Dan started us out with. The Elections Clause gives it sufficient authority to stand alone, at least insofar as we're talking about federal elections. So it sort of percolates along, and we don't actually need to answer that question for a long time. In the last 3 years, though, there's been a strange development, I might say a nonsense development, but a deeply consequential development under the Voting Rights Act in terms of the private enforcement, the availability of private plaintiffs to bring in these claims. I'll say more about that in just a moment. But because of the way the Voting Rights Act is written, and it links, I will say, private enforcement to language in the statute that says it enforces the 14th and 15th Amendment, the question kind of is percolating up for the first time, even though it's been around for a long time. I think the windup also helps a little, and again, maybe I'm going to just keep it, but to contextualize the way voter harassment has changed, or the new examples of it we see. So the paper talks a little bit about two prominent examples from the 2020 election: the robocalls that were sent to Black voters in Detroit, in Michigan, in Ohio, Pennsylvania, New York, am I missing something, and Ohio, telling voters a whole slew of misinformation about the consequences of filling out a write-in ballot. It was a deliberate attempt to suppress the vote. As I say in the paper, I'm an easy sell for that being a violation of 11B. One court so found. Voter harassment, intimidation, targeting a racial group. In fact, 11B doesn't require that, but this was done for that. And the other case that I talk about in the paper, and the one that really has brought forth this private enforcement question, because it's is the case of Mark Andrews in Atlanta. He's putting absentee ballots in the middle of COVID in a drop box. In Atlanta, it's his ballot, his wife's ballot, his adult children's ballot, gets picked up on security footage. And that footage ends up in the movie 2000 Mules, in which it accuses him of engaging in a massive scheme of voter fraud. His picture, his license plate, appears repeatedly, not just in the movie, but in promotional materials. And he brings a suit on a bunch of grounds, one of which is this is voter harassment within the meaning of 11B. And the court there, that's where the court actually says, maybe, but you're the wrong person to bring this suit because you're a private person. The legal question I'm talking about is solvable. Congress could fix this in 5 minutes. This Congress won't. We'll see whether the next Congress will. So in some ways, the stakes are through that lens. Let me just say a quick word on the private right of action. You may have heard some of this because it has made it into the national news. Private parties have been enforcing the Voting Rights Act from the get-go. This was something I never thought about as being a particular issue. 3 years ago, in one of the cases Josh mentioned, actually, Supreme Court cuts back on Section 2. And in so doing, Justice Gorsuch drops a concurring opinion to flag one thing. And the thing he's flagging is, we've never decided whether private people can enforce Section 2 of the Voting Rights Act. You're like, yeah, well, we haven't, technically correct. And the invitation was, I don't think they should. And within months, we have a district court in Arkansas that says, no private enforcement. That rule has been adopted by the 8th Circuit. Should it go to the Supreme Court, which if Congress doesn't fix it, it will eventually. It will be the national rule. I have little doubt that 5 justices will sign on. I'll also say it's a nonsense rule. I'm happy to talk about it. It's the kind of decision that when you teach to your students, it's really hard to say, let's take law seriously because of the moves that are being made in that. But I'm going to put that to one side. I'm happy to complain about that. But we're going to talk about something else, which is the Andrews suit, where the court actually leaves that aside. Yeah, that's all going on. I'm not denying that there's private enforcement of the Voting Rights Act, but 11B is different. And it's short analysis. It's short analysis. The case gets, the claim gets thrown out. And I'm reading a lot into that analysis, but the analysis is something to this effect. The language in the Voting Rights Act says that it anticipates, conceives, states. There's a debate about that, but there's language in the Voting Rights Act that anticipates private enforcement of statutory provisions that themselves enforce the 14th and 15th Amendments. And that's where the court in the Andrews case kind of said, not so sure there's a linkage there. And that's where this question and that's the whole lead up. That's where this question comes up, and the court pretty much assumes it doesn't because it's reaching private action. And that's where the gender motivated violence issue comes in. And this is a case from 2000, United States versus Morrison, where the court strikes down a provision of the Violence Against Women Act, private remedy, saying private action beyond what Congress can reach pursuant to the 14th and 15th Amendment. And 11B structurally looks a little like that and seems to share that same defect that the court recognized in Morrison, namely this idea that it's not really acting on any state action. It's not changing or affecting a constitutional violation by the states. So the draft, the idea is, but 11B does, that voter harassment, we should understand this to be different. We should understand voter harassment to be different. And what I try to sort of, I would understand what's the constitutional right that voter harassment, privately initiated voter harassment and intimidation acts upon? What is it doing? And in part, we saw it in the framing. You look at the legislative history of this provision, the head of the House Judiciary Committee gets up and says, we're enforcing the 14th and 15th Amendment. 11B enforces it, explicit, clearly understands this to be that. And one of the things that's said is that it's affecting or it's targeting states that are refusing. States that are refusing to protect voters. States that are refusing to do anything when this stuff happens. And what I'm trying to push, and I caveat, the court's not going to buy this. And this is not a litigation strategy, but rather an argument for us to consider that there's a competing or an additional, more robust conception of the right to vote that we should embrace and defend. And that the notion here, and the paper tries to do this with a little bit of a temporal argument, that voter harassment acts as intertwined on the right to vote free and uninhibited, free from harassment, that it does that sort of at the same time. It's a way to try and cabin Morrison, but it depends on a conception of the vote and the conception of state action with regard to the vote. The states are failing to protect voters, not just because they are deliberately interfering, not just because they are refusing, we don't care, but in fact, they are necessarily going to fail. And we see these more recent examples of voter harassment. There's not a constitutionally acceptable way for the states to fully prevent stuff like this from happening. And despite their best efforts, despite the fact that prosecutors in Ohio, in Michigan, in New York went after this afterwards on the robocall example, it's still going to happen, right? It's still going to happen. And I want us to understand that the idea that's being presented, that I'm presenting here, is that the necessary inadequacy, the unavoidable failure of states to prevent all of this harassment is part of an infringement on the right to vote that Congress can step in and pass this 11B. That's sort of targeting that. I know I'm out of time. I think there's more to say. I actually have a thing about the white primary cases, which has a really complicated thing about state action, right? And there's a way to sort of say the failure of the state. It's not that state inaction is unconstitutional necessarily, but that private harassment, privately initiated voter intimidation operating in an ecosystem in which state efforts to prevent it will necessarily fall short, gives rise, sounds in constitutional doctrine sufficient to justify 11B. And I'll stop there.
Or just some, it is, I just need to refresh the PowerPoint. It should. It is, right. I don't know if the clicker works, but you could just use the, oh, it does, fantastic.
Yep. All right, hello, everybody, and many thanks to Dean Dan and to Miriam and Rob and to the Law Review editors for putting together this terrific symposium. I've got to say, it's always wonderful to be back in Madison, which is one of my favorite places in the whole world. I've been coming here now for about a decade, ever since I first got involved in the Whitford v. Gill partisan gerrymandering litigation. But this visit is special because it's my first time since my first visit to Wisconsin, in which Wisconsin has fair maps instead of gerrymandered maps. So it's really great to be here for that reason. But so I'm not going to be talking about redistricting today. Instead, I'll be talking about proportional representation, or PR. And in particular, my proposal for a new form of PR, which I call ranked list PR, and which I think has some distinctive properties that make it especially attractive in the American context. So PR is getting some attention these days. There's some buzz around PR, at least in the circles that I'm in. Portland, Oregon recently adopted proportional ranked choice voting, which refers to multi-member districts that use ranked choice voting to elect more than one candidate. Some other cities around the country, smaller cities, have also recently switched to proportional RCV after Voting Rights Act litigation. Groups like Fair Vote and Protect Democracy and New America are aggressively pushing various PR proposals. And I'm aware of various initiatives to push for PR, including at the state level, that are currently in the works. So why is there attention being paid to PR right now? This won't come as a surprise to the election law scholars in the room, but PR offers a range of democratic benefits. The first and most important is probably fair representation for political parties. So legislative representation for parties that corresponds to their level of political support among the electorate. PR also promises fair representation for minority, racial, ethnic, and other groups. There should be more electoral competition under PR because even when a district is far from 50-50 under PR, parties can still win or lose seats, which is not true with a single member district. PR seems to be associated with less legislative polarization, more legislative bridge building, coalition building. And closest to my own heart, there's comparative evidence looking at multiple countries that finds that PR leads to better alignment between public policy and public opinion when compared to traditional US-style first-past-the-post elections. However, leading reformers in the US still have some concerns about the major existing systems of PR. So I mentioned proportional RCV a minute ago. This is the Portland, Oregon system. It's also the system that Cambridge, Massachusetts, where I work, uses. So scholars like Jack Santucci have argued that proportional RCV may not be viable in the long run in America because the major parties hate it due to what's called vote leakage, and they continuously try to kill it. Vote leakage refers to the phenomenon where a voter ranks one party's candidate first, but then candidates from other parties second or third or fourth. And depending on what happens in the vote tabulation process, that voter's vote might end up helping candidates from other parties, not the first choice party, to be elected. That's called, the vote leaking from the first party to other parties. With respect to the other great form of PR, which is called party list PR, This is PR where voters vote for a party, and then candidates are elected from the party's list in the order specified by the party. The big concern here is that party list PR may often violate the Voting Rights Act because it may not guarantee sufficient minority representation to satisfy the VRA. So the system that I'm proposing, ranked list PR, I'll explain in a minute why I think it resolves both of these concerns about existing PR models. Let me first explain what I mean by ranked list PR. So it's basically a hybrid of the two most prominent existing PR systems, which are party list PR and preferential ranked choice voting, also known as the single transferable vote. So under ranked list PR, as under regular party list PR, voters would first vote for a particular political party. Then, however, voters would only rank this party's candidates. They wouldn't rank all parties' candidates as they do under proportional RCV. And then voters' rankings of the one party's candidates would determine which of that party's candidates win the allotted seats for that party. And so the point here is to ensure a kind of double proportionality. Proportionality among parties through the initial party list vote, and then proportionality within parties as well through the rankings of the party's candidates. So here's an example of what a ballot might look like under ranked list PR. So let's imagine there are three parties, the green, orange, and purple parties, and there are 5 seats in a district here to be filled. And each of these parties runs 5 candidates for those seats. A voter would then have to choose one party to vote for. So here, for example, the voter votes for the purple party. And then the voter would have to rank the purple party's candidates. And here we see one potential ranking. Candidate L is first, candidate K is second, and so on. How would an election as a whole work under ranked list PR? Well, let's suppose that 60% of voters in this 5-seat district support the purple party. Well, then the purple party is entitled to 3 seats. That's 60% times 5 seats. The math then starts getting a little bit trickier, but it's not actually any different from what's normally used under proportional RCV. The quota for election for the purple party's candidates would be 25% of the purple party's total votes. That's because there are 3 purple party seats. The quota is then 1/3 + 1, or 25%. Candidates with more than 25% first place votes from the purple party would be automatically elected. And then you'd use the standard RCV reallocation of preferences to determine who else is elected to the remaining seats. This might sound complicated, but this is exactly how proportional RCV works, and so I won't go further through these details. So what are the advantages of ranked list PR compared to existing PR systems? The first one is that I think the major parties should prefer ranked list PR to proportional RCV, which so far is the only kind of PR that's been tried in America. And that's because ranked list PR completely solves the problem of vote leakage. Under ranked list PR, it's simply impossible for votes to shift from higher ranked candidates from one party to lower ranked candidates from another party. Under any party list system, that kind of vote leakage is impossible. And so I think that means that the major parties should be less hostile to ranked list PR than they were to proportional RCV back when it was used by a bunch of cities in the mid-20th century. So in that time period, as Jack Santucci and others have written about, the major parties hated proportional RCV because of the vote leakage. They kept mobilizing to oppose it, and they eventually succeeded in getting rid of proportional RCV in almost every single city where it was used. I don't think we'd have the same relentless opposition to ranked list PR. The other big advantage of ranked list PR in the American context is that it should be more compliant with the VRA than party list PR, the other great existing PR model. There are two main kinds of party list PR, and both potentially lead to VRA problems. So closed list PR is the standard form of party list PR. Here, the party just decides on its own what the ordering of candidates will be on the list. And the VRA problem here is that this makes party insiders, party bosses, totally responsible for whether the electoral system will or won't comply with the VRA. If the party bosses rank enough minority preferred candidates high enough, then you might get VRA compliance. But if the party bosses don't rank enough minority preferred candidates high enough, then you may have a VRA violation. The other main form of party list PR is known as open list PR. And so here a voter votes for both a party and for a single candidate within that party. And this effectively creates what electoral system scholars would call a single non-transferable vote election, or an SNTV election, within each party. And the problem here is that SNTV is well known to be a semi-proportional or sub-proportional system, not a system that guarantees proportional representation for minority groups, including racial and ethnic minorities. And so again, with open list PR, there's a real danger of underrepresenting racial and ethnic minority groups. In contrast, ranked list PR almost necessarily achieves intra-party proportionality for cohesive minority groups. And that would likely translate into overall proportionality for those groups too. The existing American system of PR, proportional RCV, is well known for ensuring overall proportionality through its ranking mechanism. And ranked list PR would rely on exactly the same ranking mechanism, which ought to result in the same very good consequences for overall racial and ethnic representation. Let me just close by mentioning a few final issues that I'm still thinking about with respect to ranked list PR. One is it constitutional under the federal constitution? As with other forms of PR, I don't think there's any necessary conflict between ranked list PR and the federal constitution. There's a federal statute that would have to change for any form of PR to be adopted at the federal level. But in this respect, ranked list PR is no different from any other form of PR. However, at the state level, there is a problem. Over the last few years, a bunch of red states have passed laws targeting single winner ranked choice voting. And you'd have to look at the wording of each of these laws. But it's quite possible, even likely, that some of these laws would also prohibit ranked list PR, because they seem to prohibit any electoral system that uses any kind of ranking of candidates, and ranked list PR would fit into that bucket. Next, another really tricky issue with ranked list PR is, do you combine it with a primary election? If so, what would the rules be for the primary election? Would you also have ranked choice voting in the primary election, or would you have some other system in place? And how many candidates per party would advance from the primary election to the general election? Would it be the same number as the number of seats to be filled, or some other number? If there's no primary election, and note that you don't need a primary election, you could move straight to a general election with ranked list PR. But in that case, it becomes critical which candidates get ballot access in that general election. Does the party decide who gets ballot access, Or can anybody run under whatever party banner they want if they get enough signatures? And I'll note just in closing here that some potential answers to these questions might raise constitutional issues. Because if you are going to dictate to a party how it's going to choose its nominees, that may raise issues under First and 14th party associational freedom cases. So I'll stop there. I'll be delighted to hear your questions and comments on this proposal. Thanks.